broadcast is now starting. All attendees are in listen-only mode.
Happy Thursday, everyone. Welcome to today's webinar on Holiday HR. I'm Anna Hobson, the Marketing Manager at the American Chamber of Commerce Resources, as well as HR Simple. Today's webinar will be given by Gary Wheeler from Constangy. Constangy writes our New Jersey Human Resources Manual. Today's webinar will be about 60 minutes long, and at the end of the presentation, I will provide SHRM and HRCI codes. If you have questions, feel free to submit them in the chat box, and I'll be reading them off at the end of the webinar. If you do need to go over the webinar again, it will be posted to our YouTube page, which is under the name HR Simple. Gary has represented employers exclusively in both the private and public sectors since graduating from law school in 1997. His experience includes successfully defending employers in all aspects of labor and employment law. Gary is admitted to practice before the United States Court of Appeals for the 11th Judicial Circuit, as well as the Florida State Bar. Gary is a frequent lecturer at seminars for employers. He provides in-house training on workplace issues to supervisory and management employees. So at this time, I'm going to go over and pass this over to Gary so we can get started on today's presentation. And again, if you have any questions, Gary will be able to answer them at the end.
Good afternoon and happy holidays. I hope you're doing well wherever you are today. Well, let's dive into today's topic like a plate of Christmas cookies. These are the 5 areas that we're going to cover today. The first is holiday parties, and it's not just holiday parties, but it's holiday issues, gift exchanges, apparel, decorations, establishing and reminding employees about expectations for all these events. Our second topic will be year-end bonuses. Paying bonuses to employees require payment of more overtime wages. The third is time off. Juggling time off around the holidays can be difficult for managing absenteeism. And one question we'll cover is, do employees who don't follow the rules get away with it and penalize those who do? Fourth, we'll be talking about kind of a subcategory of absenteeism, and that's weather-related absences, and we'll talk about that briefly. And then finally, we'll close up with Revising Employee Handbooks for 2020. What are some of the issues that you should be thinking about as you handle that kind of project? So here we go. First, holiday parties. And holiday parties at work can be fun, they can be stressful, a chore, or some combination of all those things. But they also present risks. We're going to cover 2 broad categories of risks today. One that's related to potential religious discrimination, and those related to alcohol and potential sexual harassment. In this post-Me Too era, can employers even have holiday parties? I think you can, but the days of planning a party without thinking about legal risks and taking some practical steps to avoid them are over. Since we're talking about legal risk, I want to briefly cover some of the labor laws that could potentially be violated. Laws that preclude discrimination based on religion or sex include Title VII, which is a federal law, and similar state statutes. For example, I live in Florida, and in Florida, we have the Florida Civil Rights Act, which prohibits discrimination for most of the same characteristics that are protected under federal law. Additionally, many states have laws similar to Title VII, and you should be aware of those because while there is some overlap, there are oftentimes state protections that are broader than federal protections. And additionally, if you work for a governmental employer, employees have freedom of speech and association rights to consider. Well, let's take a look at some of religious affiliation data in the United States, because that's going to be relevant to our holiday party and holiday observance discussion today. Well, here's a breakdown. Christmas is a Christian holiday, and Gallup polled adults in 2017 to 2018 on their religious identification. Those who identify as Christian or some Christian denomination still comprise more than 50% of the respondents. So it's not surprising that holiday parties are still mainly celebrated in December. So how should employers approach holiday decorations? For example, should they encourage them by actually paying for them out of the employer's funds? Should they allow them to be displayed by individuals around their work areas, but not in common areas, or do something different? Well, the EEOC's position on this is pretty permissive. You'll see that the EEOC here in the green says secular decorations may be displayed in the workplace without violating Title VII. As you can see in the red, there's some examples of what might be secular decorations, wreaths, Christmas trees, lights, Santa Claus, reindeers. And Title VII doesn't require that an employer add holiday decorations associated with other religions. So while it's not prohibited, religious decorations are generally more likely to lead to conflicts or claims that the decorations displayed are more offensive or somehow non-inclusive. If employers want to draft rules on displays, what's permitted and prohibited to reduce conflict, here are some factors to keep in mind. Generally speaking, the more private the area, the more freedom you can give employees, and the less likely it is to offend others. Okay. So, what about holiday attire and dress code policies? Well, one thing I'd recommend is you rely on your existing appearance and dress code policies and revise those if needed. But rules are rules, but you don't have to and shouldn't be enforcing those so strictly that you fail to consider reasonable accommodation requests when those are made. Sometimes those are made by employees that have another religion, and generally speaking, accommodations at least require employers to consider making an exception to some kind of rule in the workplace, and those should be handled on a head-by-head basis. And here we've got a few examples of religious attire that maybe involves headscarves. Sometimes that becomes a safety issue, but just consider religious accommodations when you're thinking about holiday attire. Okay, so here's some ideas for planning for holiday parties and executing hopefully a holiday party that will reduce risks of discrimination claims. These are just some practical ideas for planning ahead to avoid or minimize people not feeling included. So one of the things to make it clear about holiday parties, gift exchanges are voluntary. Gift exchanges should observe employers' conduct rules. Consider an interfaith calendar to avoid scheduling conflicts with other religious holidays, and provide a diverse menu items on your menu. Okay. A holiday party setting does not do much to change the legal factors of limiting when an employers can and can't be held liable for the bad act of their employees. It does, however, ratchet up the risk factors, especially if alcohol is served. So here's kind of an example of some of the principles that apply in a workplace setting. Generally, employers are liable for the legal wrongs committed by their employees if done so in the course of scope of their employment. And some of the factors that impact whether an employee's acting in the course and scope of his or her employment, or is it attendance at the party required? Is it on-site or not? Is it held during work hours? Is it compensable? And does it advance the employer's business interests? You also want to be concerned about workers' comp issues, not just discrimination, but trip and falls, accidents that might occur, and intentional conduct like sexual assault or battery. Okay. Typically, with intentional conduct like sexual assault or battery, employers won't be held liable unless they somehow ratified the conduct. And ratifying the conduct means they somehow approve of that conduct. Here's a few other ideas for hosting parties that are likely to reduce your risks, especially when alcohol is served. So here are some ideas that potentially reduce risk. Have a happy hour and then stop serving alcohol. Hire a third-party vendor. Limit the number of drinks. You might provide 2 or 3 drink tickets at the beginning of the event. Encourage designated drivers, or provide through the company alternative transportation through the company. And you might limit the duration of the party, or intervene in the case that you find somebody is inebriated and probably incapable of driving. And strictly prohibit underage drinking if you've got people attending that might be under the drinking age. Okay? And a few things that aren't listed here to keep in mind is you might have a cash bar instead of an open bar. You might limit what you're serving to beer and wine instead of hard liquor. But all of these are just basic common sense ideas to make your party less risky affair for the company. Just keep in mind that there was no he was drunk defense. So holiday parties, the same rules apply at the holiday party as they do in the middle of the year. So just sum it up with regard to holiday parties, employers can still have them, and they can still serve alcohol, but some careful planning and execution is in order to avoid the unwanted cost of employment litigation that might follow if there's some unwanted events that take place during those parties. Okay, so we're going to move on to our second topic, and that is year-end bonuses and how those might impact overtime payments to your employees. So as one of my supervisors said right after I graduated from college, money is the right size and right color as a gift. So year-end bonuses are very popular and welcome benefit to employees, but employers need to consider the legal impact of paying those when it comes to determining, of course, taxation, but we're focusing today is calculating overtime pay. This section applies to employees who are overtime eligible or what we call non-exempt under the Fair Labor Standards Act. When an employer pays bonuses to non-exempt employees, the Fair Labor Standards Act recognizes 2 types of bonuses: discretionary and non-discretionary. Discretionary bonuses, there is no impact on overtime calculation, and with non-discretionary bonuses, the regular rate needs to be recalculated. Okay, now, as it may come as a shock to you to learn that most bonuses are non-discretionary. This is mainly because the term non-discretionary has a different meaning under the Fair Labor Standards Act than it does in common usage. To reduce this confusion, if it were up to me, I would just think of a new name for FLSA non-discretionary bonuses, like typical bonuses. That would certainly help avoid some confusion, but we'll cover that and help reduce that confusion for you. Okay. Well, since non-discretionary bonuses are the most common, let's start with understanding what they are. So here is kind of factors or examples of what non-discretionary bonuses are. They are announced to employees to induce them to work more steadily or more rapidly or more efficiently, or to even just remain with the company. You can provide attendance bonuses, individual or group production bonuses, bonuses for accuracy of quality of work, or bonuses contingent on the employee continuing employment until the time the payment is made. So what's important to understand is none of these categories changes if we were to add at the discretion of the company at the end of it. More on that when I cover the definition of discretionary bonuses. So here's an example of how we would calculate overtime after the payment of a bonus. This example is if the bonus was paid for some kind of production in a work week. So it's $100. Let's say the employee worked 50 hours, the non-exempt employee worked 50 hours in that week. Therefore, the employee's regular rate would increase by $2 for every hour the employee worked in that 50-hour period. Okay? And so with an increase of $2, here's how we calculate that bonus payment or the overtime due because of the bonus. You take the $100 that's paid, you divide it by 50, and multiply that by the halftime. The halftime is due because it's an overtime premium, and you multiply that times the over 10 hours of overtime work, and you come up with $10. So in effect, the $100 bonus that you pay to this employee effectively becomes a $110 obligation to the employer. So, well, let's talk about if the bonus was earned over a several-week period. But overtime is only due for those work weeks when a period of overtime is worked. So here's an example. Let's say that for a quarter, a 13-week period, an employee was paid a $1,000 bonus for that quarter. 50 hours were worked in 6 of those weeks, 6 of those 13 weeks, but in the other 7, no overtime was worked. Okay? So here's how you calculate the overtime due. You take the $1,000, you divide it by 13 weeks, and you'd take that number and divide it by 50 total hours, and you multiply that times 1/2 of the overtime obligation that's due and on top of the regular rate, and you multiply that times the overtime hours for 6 weeks, and you come up with $46.15 that increases that is due to the employee as a result of the bonus payment. Okay. So is there a way to avoid the administrative burden of recalculating every employee's regular rate of pay and overtime when paying bonuses? Yes, and here's an example of how you could do that. By paying bonuses a percentage of their compensation rather than a flat dollar amount. Okay, so no additional overtime is due when the bonus is a percentage of the total compensation, or at least the straight time plus legally required overtime. So the percentage bonus is said to already include what's required overtime pay. So an example here would be, let's say an employee earned $32,450 in a straight time in statutory overtime in a year, and a bonus was given of 10% of this figure. So you pay the employee $3,200 or $3,245. So no additional overtime needs to be paid. That amount could be paid less whatever deductions that you had to take out, and you wouldn't have to make any recalculation of overtime. So that's the easiest way to do it. Okay. All right. Well, remember when I said that discretionary bonuses are the exception rather than the rule? Well, here's why. Discretionary bonuses may be excluded from the regular rate, and what makes it discretionary? The fact of a payment is at an employer's sole discretion. The amount of the payment is at the employer's sole discretion. The determination by the employer is made at or near the time at the end of the period, that is, right, very close to the time it's actually paid. The bonus is not pursuant to any employment contract or promise causing the employee to expect the payment. And bonuses provided by a collective bargaining agreement are not discretionary. So, but outright gifts, those are discretionary bonuses. So giving an employee $300 on, let's say, the Friday before Christmas is discretionary. So gifts and discretionary bonuses are essentially one and the same. What makes a gift? It's made at Christmas time or other special occasion as a reward for service. The amount is not measured by or dependent on hours worked, productivity, or efficiency, and it's not paid pursuant to any contract. So it's a fairly narrow definition of what a gift or discretionary bonuses are, but the good news is that it doesn't result in having to pay an overtime premium in addition to what you've already paid. Okay, well, that concludes our second topic, and let's move on to time off or managing absenteeism. The holidays can be a challenging time for managing time off or absenteeism because of travel, people being out for vacations. Sometimes people get sick during the time. So one question is juggling time off requests. Are abusers, especially those when it comes to the Family Medical Leave Act, rewarded for not following the rules, and do people who follow the rules end up getting penalized? Okay. Well, let's just briefly let me cover the FMLA. The FMLA requires covered employers to provide unpaid time off to eligible employees for a number of family and medical related reasons. Essentially, if employees are eligible for the Family Medical Leave Act leave, their absences cannot be used as a negative basis for evaluating his or her performance. If you have a points-based attendance system, for example, and an employee is out because of an FMLA reason, then that employee's absences cannot be counted as an absence or occurrence pursuant to that plan. So what if employees are taking time off for work for one or more of these activities around the holidays? Working a second job, shopping or running errands, failing to actually care for family members, taking or extending a vacation, partying or other recreational activities, engaging in manual labor. The assumption behind this is that the employee has not been honest with you when they tell you that they're taking time off from work and they're actually doing one of these things instead. If you discover that they're not being honest with you about why they're missing work, what can be done? Anything? Okay, well, yes, there is something you could do. If you're familiar with the FMLA compliance, you know that the regulations are an important part of employer compliance. The vast majority of time, employers should rely on the regulations to determine how they should respond to requests for time off. One big exception is when you honestly believe an employee is lying to you and is actually taking time off from work for an illegitimate purpose. In those cases, employers can rely on what's something called the honest belief rule. So what is the honest belief rule? Well, it's a judicially created defense. That means instead of being crafted by the Department of Labor, it's crafted by the courts. An employer does not violate the FMLA if the employer takes some kind of adverse action against employees when it has an honest belief the employee did not take the leave for the FMLA's intended purpose. Okay, so how do you know if you're being lied to? Occasionally employees will admit it, particularly to a coworker, and that coworker may turn them in. Sometimes it'll show up in their social media. Sometimes surveillance could be a valuable asset. And you might want to implement policies to curb abuse. And what do I mean by that? Well, for example, while it may sound obvious, you should have policies in place that prevent employees from working a second job while they take time off for medical reasons. So someone may have a stressful job and take time away from work and then say, well, it didn't bother me to cut lawns or help with my father's landscaping business, so I took time off from work. Well, you can actually have a policy that says if you're taking time off pursuant to one of our leave of absence policies, you're not entitled to work a second job, or at least without approval by human resources. And the same's true of travel. Sometimes you'll find an employee taking time off for an FMLA-related reason and suddenly find them on the ski slopes. So you can actually have a policy in place that says, hey, listen, if you're going to take time off for pursuant to one of our leave policies, you can't travel more than 50 miles from the place of employment without some kind of approval from HR for it to be approved leave. So that's another example of the way you can rein in abuse of the Family Medical Leave Act. Okay. All right. Well, this is kind of a subcategory of time off section, which is weather-related leave absences. And I think the best way to cover this is just kind of have a little bit of a quiz on that. So here's a question for you. And okay, if we want to take a look at this, is when there is inclement weather, what are the things that you can do? Which one of the things is not permissible under the Fair Labor Standards Act? So we're looking for the answer that is not permissible. One is close the facility and do not pay non-exempt employees for hours that were scheduled to work. B, close the facility and do not pay exempt employees for hours they were scheduled to work. C, keep the facility open even though it is unlikely the employees can get in, and do not pay non-exempt employees. And finally, D, keep the facility open even though it is unlikely the employees can get in, and do not pay exempt employees who can't make it. Okay, so of all those answers, which one is not permissible under the FLSA? Well, here we go, and it is letter B, rather. Close the facility and do not pay exempt employees for hours they were scheduled to work. Well, this is because the employees who are exempt must be paid their weekly salary regardless of the quality or quantity of their work. Now, there are some exceptions to this rule, but closing the work facility for a day and then not paying your exempt employees for the day is not one of those exceptions. So if you need to close your place of work for a weather-related reason, you really do have a lot of options how you can and cannot pay your employees. Just realize that not paying exempt employees for hours they were scheduled to work is unlawful. So that could present a problem for not only that employee, but anybody who shares that exemption and is in that category. Okay. All right. Well, let's get on to our last topic of the day, which is employee handbooks, revising those for 2020. December is that time of year that many HR professionals revise their employee handbooks to comply with recent changes in the law. And what I encourage HR professionals to do when they are making changes is, if you're going to make changes that you have to make, consider making changes that might also be good to make, simply to make the handbook better, more readable, and more likely to help your organization. So before talking about legal compliance type changes, I want to talk briefly about some more of practical changes that I think can make your handbook more readable and likely to be used by your employees and supervisors. One is to go through the handbook and revise it with an eye towards eliminating redundant language. I make the analogy with an employee handbook. Sometimes it can be like a garage. You store a lot of items in your garage, and after a few years of living there, it becomes overcrowded because you've just added to the items that you store and haven't purged it of things you don't need anymore. And this can be helpful not only just to the length of the handbook, but sometimes when you have multiple policies, they overlap, and sometimes they'll have inconsistent provisions. For example, you may have an open door policy that says, in the event of a problem, call your immediate supervisor. However, with regard to another policy, sexual harassment, it may say call human resources or the director of a department. Now, you may have made that distinction because you want it that way, which is fine, but you need to look through your employee handbook and for kind of similar type provisions. Those provisions are very important to review, is the ones where you encourage employees that have some kind of concerns about notifying the company. You want to be consistent about the ways that you communicate those to employees and not make them confusing. And certainly don't cut and paste provisions from the internet referring to a position that you don't have. For example, if you don't have, an HR employee relations manager, then don't mention employee relations manager in your employee handbook if that's not a position that exists in your company. That'll help you, or that might cause you to lose a little credibility because it looks like you didn't spend time in the handbook and you just cut and paste it instead of customized it to your office environment. Okay. Another tip is to involve the users of the handbook. Certainly, managers and supervisors are going to be users of this handbook. They're going to be answering questions for their employees, and they're going to be consulting it to decide how to answer questions from their employees. So if you involve them instead of just handing them the handbook and say, well, this is our handbook, it'll be helpful to you because they'll be more likely to use it. And then finally, when you distribute your employee handbook, you may want to consider also having some training done with regard to new provisions with your existing employees. And of course, if you have existing training or orientation for new employees, you'll want to make sure that you update that training as well so it incorporates the latest provisions of your handbook. Okay. All right. Well, let's move on to some of the more legal-oriented changes that you may find that you may need to make in 2019 going into 2020. So I recently completed a review for a client who had operations in all 50 states, and I can tell you that the most frequent changes that I made to employee handbooks were those related to changes that were driven by the states in which they operate. Not federal law, but state law. Of course, there are 50 separate states, and it's becoming more and more popular for states to provide protections to employees that don't exist in federal law. The most common amendments or new laws are those with regard to time off, paid leave, and the EEO, or the anti-discrimination and harassment laws. Okay. Basically, what we're seeing with those is paid sick leave laws. There's sometimes leave for new parents, and some states are actually having paid leave laws that don't require any specific reason whatsoever. Those are more rare, but those are coming online as well. And with regard to discrimination and harassment, usually what you see is just additional protected classes being added in and causing a need potentially for updating your employee handbook and your training. And let's move on to that particular category. Okay. Here's a list of the several states that have bolstered their anti-discrimination laws and a list of what they've added to those laws. Again, this is just a starting point for you. Don't rely on this as being kind of comprehensive. If you operate in any of these states, consider whether your handbook needs to change and whether you need supervisory compliance training to supplement your handbook changes. But you'll see California recently had hair discrimination prohibition added into their anti-discrimination and harassment laws. And Connecticut is more about not adding a specific training, a specific category, but requiring training for employers in their state. So, and then you'll see several states added gender identity and sexual orientation. And then Illinois added a protection for characteristics that are either actual or perceived. So again, this is just a list of a starting point for you as you go into 2020 and are considering, how do I get started? What do I need to look for to see what may need to change in our handbook? Okay. And the second category of big changes was paid leave. And here are three categories that have been popular for states to pass legislation in to protect beyond that that's already protected in federal law. Family medical leave. Now, of course, there are federal protections under the Family Medical Leave Act already. However, what we see here is sometimes the employer will lower the threshold for the number of employees that need to work for an employer. So smaller employers will have obligations. Sometimes the leave will add additional reasons for the leave, or maybe additional time that the employee can be away from work. But anyway, in the last few years, the states that have had changes or may have changes coming into place: Massachusetts, California, Maine, Vermont, and New Jersey. So if you have operations or employees in any of those states, you'll want to check those out and make sure that you bolster your changes. Sick leave, there have been some paid sick leave amendments, or actually brand new laws in states like Michigan, New Jersey, and Maryland. So you'll want to check those out. And then something that overlaps with family and medical leave a bit is the pregnancy and parental leave, and some states that have recently adopted those kinds of changes are Vermont and Rhode Island. So those are the big changes that we see that should be incorporated into employee handbooks, or at least consider whether you need to make those changes if you have a footprint where some of the states are places where your employees work or you have operations. So, but that is it for the planned material that I had to go over. I'd be happy to take any questions that anybody has on anything we covered, any of these 5 categories. So just let Anna know, or Anna let me know, and I'll be happy to answer this question.
We did have 2 questions, Gary.
All right, sounds good.
The first one is, how should I dress in appropriate holiday attire?
how should you address inappropriate holiday attire?
Yes.
Okay, well, you know, there's two ways, I guess, to handle it is, you know, is it something that could be repeated for an event, and you want to just discourage them from doing it again, or do you want to basically send them home, or, you know, require that they put on a jacket or something to cover that up? But I guess it depends on the facts and circumstances. But you know, the best way is to come in equipped and know what your attire rules are already, and to address that and reference your rules. And you want to make sure that you're enforcing it even-handedly. And if you do require the employee to make some kind of change, just remind them of the rule, and remind them that the holidays don't provide any kind of exception to your attire rules. So those are just kind of two general points. And if you don't have anything coming up, sometimes one of the things that's helpful is to circulate kind of for your informational email before holiday parties, and it could be about attire and your conduct, and just kind of an open-ended reminder. It's not specifically pointing to any one employee in particular, but it serves as a reminder and hopefully can prevent problems that you may have experienced in a prior year.
And our second question was, if an employee gets a DUI after an office party, is our company then responsible?
Okay, well, that kind of goes back to the slide that I was talking about. I'm just going to roll back to it so you can see it here. But it certainly depends. Most of the time, an employer certainly won't be strictly liable for that, but there are a number of factors that can be taken into account, which is, did it happen during the course of the scope of their employment? Generally speaking, if an employee has a wreck on their way from work or on their way home, you're not responsible for that. So, now, and there's something called dram shop laws, which are that kind of apply to when alcohol is served. And this vary from state to state, but typically employers or the host of a party, for example, if it's at a private party or if it's even just at a hotel or a restaurant, typically are not going to be liable for the legal. If it's underage, you're in very bad shape. But if it's somebody that's over 21, this is a legal drinking age, then typically, unless there's some kind of aggravating circumstances, which is the employer was aware that the person was inebriated and failed to step in and prevent that employee from driving, typically an employer shouldn't be held liable. So, unfortunately, it's like anything else, somebody was hurt as a consequence of that DUI, and they learn about the holiday party, and they sue that employee and their insurance company. They may try to go after an additional set of pockets and may come after the employer. So anyway, those are some just things to keep in mind with regard to DUI.
And I actually just got sent another question.
All right.
It says, if a vendor sends an expensive gift to the department, does the company look at this as a gift and do nothing?
There's nothing in the law that requires a company to reject gifts. Now, there are, I'm aware of certain clients that have internal rules with regard to gifts, that they won't accept gifts of, any kind. Sometimes it's above a certain amount, but there's no requirement that prohibits an organization or individual from taking gifts. But you should read your own organization's conflict of interest rules and make sure that a gift, isn't violating whatever kind of rules that you have in place.
Okay, that looks like all of the questions for today.
All right. Well, thank you very much. I appreciate it.
Thank you so much for presenting today.
All right. Thank you. You have a good day.